Okay, folks, so as you know, you just heard the session is being recorded. The purpose of recording for today, we're not sure that we are going to necessarily post these proceedings or this conversation to our website, but what we're trying to do is capture your questions and input and be able to go back and then transcribe those questions and provide you with a frequently asked questions document that will be responsive to some of the questions that folks will have today. I saw a question in the chat asking if the slides for today will be available. Yes, we can do that. And so I don't have a timing for that. We'll wait and see how many questions we have first. And one of the purposes of today, before we dive into the subject matter, is to answer clarifying questions about the regulations. Do people have questions about the draft that, or the intended final regs that they need clarified in order to have a productive conversation today? So I'm going to pause there, and I want to touch on a few questions that I have gotten in advance and provide some of the answers that I am able to provide today. So let me just find that. This might answer some questions. So one of the questions is, are there two sessions with the same information, the one today and the one to be held on January 20th, or should permittees try to attend both? Permittees should try to attend both. We may not complete the review of the template in one session. We have scheduled two sessions to provide as much time as possible. We'll see how far we get today in terms of answering questions and in terms of going through the template. And then we can determine at that point whether we do need the session for next week. If there's still material to cover, we can certainly continue to hold that. If people are satisfied with their questions and with the material, we get it covered today, then we could potentially cancel that. Let's see. So some of you have gotten a lot of bounce back emails and people who didn't receive notice. If you're aware of people who didn't receive notice and you'd like to add them, please let me know and I will try to add those to the list, or I will add those to the list. There is a question about language assistance that is needed to address the notifications, and can MassDEP provide a list of languages used by the communities? So in the template that I sent out last night, there is some links to a tool that is provided by the Executive Office on environmental justice populations. And that one of the features of that tool is it does enable you to click a link that will both identify the EJ communities and also identify the languages that are spoken in those communities for those where there's 25% or more who lack English language proficiency. So we will speak to that. John's going to speak to that in more detail during the presentation. Let's see, anything else? I think that is it. So with that, I'm going to pause for a moment and see if there are any other questions that people have, clarifying questions about the regs that people want to ask before we dive into the subject matter. All right, I'm not hearing any questions. If someone's trying to ask them, then you're still on mute. If you have a question, feel free to put that in the chat. I'll monitor the chat and we'll try to address those questions as we go along. Okay. All right. So I wanted to touch on the goals for the preliminary plan. The major goal that we have for the preliminary plan is to ensure that parties are able to meet all of the requirements of 314 CMR 16 by the date that the preliminary plan needs to be submitted, which is May 1st. and then to be able to comply with the requirements of the regulations that take effect in July of this year. And specifically, that means that that permittees will need to be able to report regulated discharges or overflows to MassDEP at that time. They need to be able to issue public advisory notifications and be able to notify all required entities such as state and federal agencies, boards of health, et cetera. On that note, we are intending to provide contact information for those state and federal agencies. I'm working on that already, and in fact, have a hard stop at 3 today because I do have a meeting with some of the other state agencies to talk about those contacts with them. Wanted to also give you an update on data system. We're aware that we need to have a functional data system in place by the time the regulations reporting requirements take effect in July. We are now meeting, we have been meeting with the EEA IT department to develop a data system. And so we are continuing to work on that. People have offered me, their thoughts about the data system, and I'm passing those along, and we are meeting with them again as of next week. We've also been asked a little bit about translation services. At this time, we are looking into being able to help provide some of the translation, being able to provide translation of the signs that would be posted at public access points and provide that language and infographics to folks so that they can utilize that. And again, we're working on that piece. Okay. Let's see what else we need to talk about. So one of the goals, of course, is to identify environmental justice populations. You'll be able to do that now using the links in the template that we've provided. And that link will also help you to be able to identify the EJ populations that lack English language proficiency, and hopefully enable you to post the translated documents, because as you're probably aware, the public advisory notification does have to be translated when they are issued. Okay, so I think that is everything that I needed to cover, unless there are questions. I will turn it over to John.
Hey, Weldon, Josh Schimmel here. Just one quick question.
Sure.
You copy?
Yes.
Yeah, just a suggestion that perhaps for your IT solution, you should create a focus group or a user group that should include some of the entities that are required to report out. It may be useful to get the input directly from us. So once you're working with the executive office there, maybe consider reaching out to some utilities or organizations to create a working group of folks who could give some input on what you're developing and some insight into how it will work or won't work.
Okay, Josh, I think that's a very reasonable idea. I'll run that by the folks in our IT department next week when we meet with them. I agree with your thinking, and that had been my thinking as well. I'll see if we can get that done.
Okay, thank you.
Thank you. Okay, any other questions before we kick it off to John? All right, John?
Yep, can everyone hear me all right? Just so I don't go too far down this road. So today's presentation, we're going to cover preliminary notification plans that are to be submitted by May 1st, 2022. Basically, the goal of these preliminary plans is for the permittees to be able to meet the requirements of the new regulations. As you saw in the regulations, final plans will be due January 12th, 2023. We will provide guidance and the requirements covered at a future date. These final plans will be posted to the environmental monitor and provide much more detail and description. But these preliminary plans are to be able to show the ability to meet the regulations. You can feel free to stop me at any point if you have any questions or comments, or just throw the questions in the chat that we can kind of keep in that running QA document. But we're going to basically cover all the requirements today that go into these preliminary plans. And if you've seen the template that Weldon emailed out yesterday, it kind of covers this in this order. So this presentation should follow pretty closely to the template, but we can kind of look at the template also after we go through the presentation, which should only probably take 20, 25 minutes. So basically in this template, we're looking to collect the permittee contact info, make sure you're able to identify your EJ environmental justice communities and any language translations that would be needed. You're aware of all the events requiring a notification, all the notification components. One of the important parts of the regulations in the program as a total is discovery of events, and we'll cover that in a few slides. Issuance of the notification timeline. There's a timeline that things need to follow. So in this template, permittees are going to need to sign off that they're able to meet this. We'll cover that. The website and a subscriber-based system where the public could sign up to receive these notifications. Signage at your CSO outfalls and public access points, and who the recipients of these notifications should be. So first component is environmental justice community requirements, and by definition in the regulations is a neighborhood that meets one or more of the following criteria. So you have an income threshold, minorities comprising 40% or more of the population. The big one that we're looking at for the translations is there's 25% or more of households lack English language proficiency. I'll show you on the next few links how to use that, and as well as how to determine where at least 5% of the population has speakers who self-identify as do not speak English very well, and identify these languages that notifications must be translated into. The fourth category probably won't impact much here for these notification plans. So these are the links, but I'm going to drop out of the presentation real quick and pull up these links. So if everyone can see this all right, it's a list of towns through the Commonwealth, and you have an M, an I, or an E. So yeah, the M stands for the minority component, the I is income, and the E is the lacking English language proficiency. So for facilities or outfalls in these towns, you can easily go through, see the different components of each one. I think for the CSO communities, for the most part, the majority do have the lack English language proficiency. So as you kind of see here, that's the breakdown. That's the first link on that PowerPoint. The second one brings you to this map. And this map breaks down all of the those different components. You can also drop in different backgrounds on it to see areas a little bit differently or a little bit easier. But you click on this link right here, and then you drop these out. And then now this map is showing you languages spoken by at least 5% of the population in the census tract who do not speak English very well. So you have that, and then you can just zoom in on a town. We'll zoom in on Lowell as an example. So you pull that up, you're able to see the map, you're able to see the different neighborhoods. Click on a track, anything over 5% in those neighborhoods would need to be translated. So in this one, you're looking at Khmer, Cambodian, Portuguese, Spanish would fall out there, but you can click on the different areas and it will show you the languages that would need to be translated for that area. So pretty straightforward. I've been tinkering around with it the past couple of days. So it gives you a quick threshold and an idea on what languages. For the most part, the languages that I've seen common are Spanish, French Creole, Portuguese, Khmer, Russian, there may be a couple more, I think Chinese. So it gives you a kind of a quick overview of the languages that will need to be translated.
John, where do we find that again?
Yep, so those are right here in these links. And the links are also part of the template. So we're trying to make that part as straightforward. So when you're going through the template, when you get into the translation areas, those links will bring you right up and you'll be able to, put those languages into the area boxes as needed. So let me jump back here. So those are the links there, and those will bring you to the maps. And like I said, it's pretty straightforward to use, and you should be able to get a quick grasp of what languages you'll be looking for translations. So I think the what needs to be translated. So your public advisory notifications will need to be translated, and provide access to translations. So the website can be a large clearinghouse for this. So the notification will have to have the access to the website and the translation. But so the access to translations can be provided by proposing the translations on the permittee's website and indicating in advisories that translations are available on the website. So each advisory that goes out isn't going to need the full translation in the advisory. It can have a link to the translation on your website. As well as your public access signage, as Zeldin said, DEP will be providing a template for the public access signage. And again, for the neighborhoods that are impacted by overflows or discharges, you're going to want to provide access to translations on the permittee's website, provide the link to the website on the sign. It may be through a QR code or universal symbol. So the translations are going to go to the public advisory notification, your public access signage, and depending on the news organization. And I cover this at the end, but I'll touch on it now. We've talked about the two largest news organizations that need to be notified of these notifications. If one of them does not serve the environmental justice population in that area, then an additional news organization would need to be added to the list to receive notifications of events. So we want to cover events and the public notification requirements. So basically, which events? Well, do you have something to say?
Yeah, John, I'm sorry. There are some questions in the chat about signage. Would you prefer to take those now, or would you prefer to hold those?
No, let's wait till I get to the signage stuff.
Excellent.
So I'm
Okay.
going to cover everything. So that was just the EJ component, but we have slides on signage coming up. So I'll take a minute to get there. Anything else?
Oh, that's it. Thanks.
Yep. So the events requiring notification, and this is important. So it's any combined sewer overflow, any discharge of partially treated water, including blended wastewater, any SSO that discharges through a wastewater outfall, either directly or indirectly into a surface water of the Commonwealth, any SSO that is surcharging due to high flows that cannot be conveyed to the treatment plant would require a notification, as well as for pump stations over 1 MGD in an SSO situation. So those are the events requiring notification. So kind of just emphasize partially treated definition in this set of regulations is this is a discharge through an outfall from a treatment works where all or a portion of the flow is not conveyed through all treatment units. So any area where you're bypassing a treatment unit would require a notification. That includes facilities with tertiary treatment. A bypass of a tertiary treatment unit would require a public notification. If a unit fails and is bypassed due to failure, that would require a notification. Some things, one area that doesn't require is seasonal disinfection. That's not considered partially treated, provided the permittee is operating its treatment in compliance with its NIPDES or surface water discharge permit. If you have a CSO treatment facility in the collection system, that does not constitute treatment. That would still be deemed as partially treated and would require a notification. And for the purpose of 314 CMR 16, all blended wastewater events are considered partially treated. So all of these events at the facility, if they were to happen, would be required to issue a public event notification. Here is all the information that goes into the actual notification, and this information has stayed pretty consistent through the different versions. So I'm not going to cover too much of this, but I'm going to cover the main areas that need to be addressed in the notification plan. in the preliminary notification plan is we want to know how the permittee is planning to calculate their estimated volume of discharge and overflows from using the average data from the prior 3 calendar years. So in your preliminary notification plan, we'd want to see how that is being done. We also want to see how the permittee is determining affected areas. So this list of waters, land areas, including names of water bodies and municipalities affected by these discharges and overflows. We're going to want to see that in that preliminary plan to see how these components are going to be handled. The big component of all of this is discovery of events. And as we kind of go through discovery of the different events, the discovery starts it, and then that triggers the notification timeline and the components of that. So I'm going to cover each of the discovery components and then cover how that impacts your notification timeline. So basically, there's a discovery from the regulatory definition is the time when a permittee obtains actual knowledge of a particular event. So permittee is going to need to describe the steps that they're going to take to determine or discover that a discharge or overflow is happening, whether it's through flow meter, model run, or other commissioner approved method. And the importance of this is making sure we're providing reliable and detecting, being able to detect reliably and measure volume properly. So what the permittee may want to provide in the discovery steps, it may be standard operating procedures, it may be something that you're currently developing, or detailed assignment of responsibilities of sewer authority staff. So we want to see what steps are being taken on the discovery side. The main discovery would be metered CSOs. So each time a permittee receives a communication of a potential discharge from a meter deployment, the permittee shall take the action set forth to confirm the occurrence of a discharge, whether that's by meter data, site inspection, or other approved method. For facilities who are staffed 24/7, that discovery period for metered CSO events is 2 hours. For non-24/7 staff facilities, discovery of metered CSO events is 4 hours. If the permittee is unable to confirm that discharge in that window, it is deemed or presumed that a discharge has been discovered. So depending on how the facility is being set up for their discovery, if you receive that meter data within 2 hours, it still hasn't been confirmed. At that point, it's been deemed discovered and would start the timeline.
Hey, John, Josh here, just sorry to interrupt.
Go ahead.
Quick question.
Yes.
Go back one slide.
Yep.
So, 24/7 facilities, the treatment plant staff and collection system staffs are usually totally different groups. So although a treatment plant facility may be staffed 24/7, most collection systems are not. So can you just, can you define that a little more clearly for us so we understand it, or will it be defined?
Yeah, so I think that's a good question to put in the chat box, and that's something we can clear up in the Q&A. I don't want to misspeak right here, but I think it's something we want to have a clear answer for all of the facilities. Like I said, some of the questions we're probably not going to be able to have an exact answer today, but I think will be followed up with at the next meeting when we can kind of get a universal answer for everyone. So thank you for putting that in. And like I said, there'll be more of these questions. So please bring them up as they come, as you see them, when they're on your mind, and we'll enter them into the QA, document that we'll start drafting after this. So we want to make sure the importance of this and the importance behind the template is to try to get everyone on the same page and have a general understanding of how we're determining what these events and timeline is. So thank you for the comment. We also have modeled CSO events. So, and for your preliminary plan, we're going to want you to provide the modeling description, what data has been used, how it's been, the thresholds have been set up, what the triggering events and what the timeline on it is. So if your system is completely modeled for CSOs, we're going to want to see those details, provide as much as possible, and see what the permittee is using to predict these events. Any non-metered approval is going to require the commissioner's review and approval. And so basically anything non-metered, so any combination of modeling, metering, or any other approach that the permittee has, that is going to require an additional approval through the commissioner. And you're going to want to make sure you're providing your historic information, correlating predicted activations with actual activations, and any additional information verifying modeling approach. So kind of a note here, any of these extensions, and we'll talk about extensions in a minute as well, are going to require commissioner's approval. Discovery of an SSO event. So whether that is based on made by any person, site inspection, pump station or alarm, or any other relevant information to the permittee, that starts this discovery timeline. And the permittee shall take no longer than 4 hours from receiving that relevant information to confirm the SSO discharge or overflow. At that 4-hour mark, if it hasn't been confirmed, it's presumed that the event has been discovered. Partially treated is a little bit different. So basically when the permittee begins diverting a portion of the flow around a treatment process, that starts that public advisory 2-hour notification timeline, as well as when becoming aware of failure within the treatment process. So that's the 2-hour window for discovery on partially treated. So you've discovered your event in that window. Step after that is now issuing your public notification. So the event's been discovered in that timeline. That starts this issuance of a public notification timeline. You then have 2 hours to issue that notification. So event's been discovered, notification has been issued in that 2 hours, you're on track. Now, if the event has stopped while that initial 2-hour public notification window is done, you can put that the event has ceased in that initial notification, and you're done with that event. Now, if when that initial 2-hour public notification goes out, the event is still ongoing or it hasn't ceased, this is when the cessation, so that 8-hour window after the initial notification, the event has stopped in that 8-hour window. At the end of that 8 hours, another update is issued, the public notification. And this is stating that the discharge is either ongoing or has ceased. If it has ceased, approximate time of cessation, and update any information that might have changed from the initial public notification. All of these notifications should be issued to the group under 314-16044, which I'll cover at the end. That last point is just what I was stating. So if you cease the event in that 2-hour initial notification, no cessation notification is needed. If an event is ongoing, you have the continuation of a notification. So instead of that 8-hour point after the initial notification, the event is still ongoing, you're not going to issue the cessation notification, you're going to issue a notification of continuation. And you're going to notify that or update that every 8 hours of an ongoing event. So, you have a 16-hour event, it's still going at that second 8 hour. Once it ceases to, or the discharge or overflow ceases, then the cessation notification should be issued within 2 hours of that. We also have the retraction of a notification. So a meter misproperly reads an activation and you conclude 36 hours later that that wasn't an accurate event and it wasn't reported properly. You can retract that within 48 hours and make sure that is issued to all the parties that we'll cover later. So with the understanding that, there is some possibility that all of these, notification timelines and discovery events may need an extension in this preliminary plan. So there is the ability to propose a method or can't meet these requirements. The commissioner may extend the time for a permittee. Shall only be extended as necessary and not more than 24 hours after discovery. Any permittee that's granted this in an extension is going to need to make the necessary improvements to address any of these shortcomings at this point and describe the measures that the permittee proposes to make the necessary improvements and a proposed schedule. So website and signage. Website is pretty straightforward. Again, you need to have a map, long-term control plans, instructions on how the public can subscribe. Any reports, CSO reports, whether they've been developed through your NPDES permanent enforcement orders, compilation of data, updated data on estimated duration, frequency, and volume, rainfall data, treatment. Website shall include data for at least the preceding 3 calendar years. I think an important one to note here, because this is not included in the notification, is the permittee on their website for each issue notification shall include information whether there was any treatment to disinfect pathogens, remove solids or other pollutants from these discharges or overflow. So for a bypass blended type event, you'd want to make sure that's being noted on the website, as well as links to anywhere where you may get the closures for shellfish areas, bathing beaches, or other resources potentially affected. CSL outfall signage, so each permittee is going to need to install and maintain a warning sign at each of its outfalls in accordance with its NPDES and surface water discharge permits. Permittees that are in compliance with their discharge permit signage requirement will satisfy this obligation. So I believe most of the CSO facilities do have signage in accordance with their NPDES permit. Those signs will meet the requirement of the notification plan. We will want photographs of the CSO outfall warning signs. Public access signage is going to be a little different. So the permittee is responsible for installing and maintaining signage at public access points to waters affected. This is where the permittee needs to meet with the boards of health or health departments in the municipalities impacted by the discharges and consult and determine where the location of these signs should be. The signage shall be developed using a template provided by the department, and that's something we are currently working on. And we should have something at some point. We'll put a date on that. So for the discharges that do impact environmental justice populations, we want to make sure that these signs have translations and utilize universal symbols. We're putting together the template, so we'll have the universal symbols on those template signs. And so the access to translations can be provided by posting the translations on the permittee's website and providing a link to the website on the sign. Permittees may also choose to use a QR code in addition to the website link. Let's see. Here are the components that the public access signage will have. They're basically going to notify the existence of the outfall, who the permittee is, information about weathers that may cause the discharge, a warning of the potential threat to public health by recreating or using these waters after a discharge, and information for the public to subscribe to notifications about discharges in local area waters. So what needs to be included in the plan for signage? Basically document the permittee has consulted with the Board of health departments, include a list of locations where the signs will be installed, and proposed dates when these signs will be installed. Now, the preliminary plan won't have photographs of the installed signs, but those should all be included in the final plan. Logan, do you want to talk about the signage question that came in now? Or?
There's been several questions that have come in on signage, John. So I think, why don't we just set aside some time to try to work through the different questions that have come in. So yes. Do you want to do that now?
Keep
or
going.
do you want to, yeah, keep going.
Through
and
the rest of it.
Sounds good.
Oh, I'm almost done anyways. There's just 2 more slides. So we want to make sure your subscriber-based notification system is available. Permittee is required to have the subscriber-based system. We want to just make sure you're providing the details on how the system's going to work. The website should have instructions and link to subscribe, public access signage, also information on how to subscribe. We want to make sure that, the public is aware of these locations and how to address or sign up for these notifications. We talked about who these notifications need to go to. So each one of those notifications that we talked about need to be issued to these contacts. This is the DEP list that will provide you with contacts, and that's MassDEP, EPA, Department of Public Health, Division of Marine Fisheries, Department of Conservation and Recreation, Division of Wildlife, Fisheries and Wildlife. So those will be provided to you in your plan. The permittee is going to be required to provide contacts for the Municipal Board of Health or Health Department, the Board of Health and Shellfish Constables, anyone who subscribes to receive these notifications, public water suppliers, and operators of any potentially affected bathing beaches as defined by 105 CMR 445. So just briefly on the news organizations. So, as we talked about, 2 news organizations needing to be notified. Those would also have to be included in the notification plan. Question to ask is, do either of these above media outlets serve the EJ population? If neither does, then an additional news organization that serves the EJ population with the impacted municipalities would need to be added. And then, so one thing to note here is, the permittee is required to send the public advisory notification to the identified news organizations. You're not required to place paid ads. You're not responsible for the news organization publishing any of the information, and the permittee has no further obligation under the regulation after they've submitted the notification to the news organization. So basically, the news organization needs to be notified, as do that other running list of organizations. But after that, the obligation for the permittee is done. So that is the end of the slides. I'll keep the slides open. I'll also pull up this. That's the template, but we might as well start some questions now. So.
Yeah, and John, let me just speak to, I was thinking about one other thing. So today's session really is on preliminary CSO plans. And as I mentioned earlier, that the goal of this session and of the preliminary plan is to ensure that permittees can comply with the requirements that take effect in July of this year. We expect that we would have guidance on a final CSO plan and be able to, and also I would assume we may want to meet with you again and talk about the final plan that is due in January of 2023. Generally, the way that I think about it is, that for the purposes of July, a permittee needs to be able to report their discharges, post public advisory notifications, have signs in place that, at public access points that can provide the required information, and be able to reach those EJ populations using the tools that we're providing in the template. And to then describe, in short detail, what types of activation, detection, and measurement is available at each of the outfalls. One of the requirements is that in the preliminary plan is that a permittee needs to request from the Commissioner of DEP permission to utilize something other than metering. And DEP must grant that permission in order for you to, be able to continue to use whatever other than metering is in place at that outfall. Now, I think realistically, no one expects there to be any type of there to be time or sufficient understanding as of July for any kind of modifications to be made to the measuring or activation devices in place at the outfalls. What we would anticipate is that in the final plan, that those would be described, in more detail, and that if modifications of them are in order, that we would hope that the permittee would make some effort to describe what, what efforts they intend to make and the schedule for making them to, change those activation detection devices over to metering or to continue as they are. If other devices are used, they need to be reliable. That's the term that is used in the statute. And so there needs to be some, assurance that a model or other method that is used for detection can in fact detect activation and can measure that activation or measure the flow. So what we are expecting is that there would be more detail provided on particular CSO, outfall, activation, and measurement devices in the final plan. And I think that kind of covers what I am thinking about in terms of the differences between the preliminary and the final plans. And I did want to mention that we do expect to be able to provide, further guidance to the group at a later point in time about the final plans. Okay. John, anything else you wanted to touch on before we turn to questions in the chat?
Nope.
Okay. Let's see. I did want to introduce the rest of the team that worked on these regs. Susie King is here. She's our MPDES section chief. Kevin Brander is here. He is section chief in the Northeast region. Deirdre Desmond, who is our attorney, is not present today. I'm going to ask for them to help me on answering some of these questions. Also want to reiterate that we may not be able to answer all the questions today and would, use the chat, a record of the chat to be able to try and respond to questions, at a point later in time. So let's see. John Sullivan asks regarding public access points, if a CSO discharges under a seawall or a harbor walk that runs parallel and above the seawall, and someone can fish or jump into the water anywhere along the length, what is the extent of the public access? I guess I would offer my preliminary thought on that was that we really thinking that it would be public access points would be, places that were designated public access points, not necessarily public land that didn't have designated access points. But I don't know if other team members have anything that they want to offer about that particular circumstance. Okay. Lucica, is that the way you pronounce your name?
It's Lucica.
Lucica, I'm sorry.
No.
Asks signage questions. Can the signs already installed at some public access points along the Alewife and Mystic as required by the CSO variances for Somerville, Cambridge, and the MWRA be used to meet the 1605C requirement? So there are a couple of, there are a few signage requirements. One is that my understanding is that some NPDES permits currently require sign postings at outfall locations, and the final regulations indicate that that any sign that is posted as a requirement of an NPDES permit will suffice to meet the requirements for those signs required to be posted at outfalls. Then there's also, for the purposes of notification to the public at public access points about the potential for exposure. And if those signs, if there are signs in place there and they meet the requirements of 1605C, then I think that they would be sufficient. If they had to be modified to fulfill all of those requirements of 1605C, then I think they, you'd have to modify or replace that sign. from Lowell Wastewater, we get, are pictograms adequate for signage, or does the sign need to be translated to the specified languages defined in the neighborhood? So we are intending to provide you with a template for signs, and we do intend to provide you with infographics, or they're sometimes referred to as universal symbols. And my understanding, and I know Susie was coordinating with our EJ director on this topic, which is, my understanding is that the language on the sign needs, there's some specific language in the reg that would alert people to the fact that there is potential exposure to, untreated or partially treated sewage. That phrase, it's a relatively short amount of text, would need to be translated on the sign. And that the signage would also need to provide a mechanism by which a person could access the full text of the sign in the languages where the EJ population in that community exceeds 5% of the population. Susie, did I get that? Did I get that right?
Some. So
Some of
the
it.
one you're thinking of where there's specific language that has to be translated, that's actually the signage related associated with the public health warnings, where there's a specific phrase that has to be translated and then other information that they could just provide access to translations. So for the signage that the permittees are responsible for, our public access points, and John has it up on the screen here. It's actually the last sentence in 16053. It says signage shall provide access to translations in the languages most appropriate for those neighborhoods and shall utilize universal symbols. So, but as Lalden said, we're going to be developing a template for this sign for everyone to use. I think it says, yeah, signage shall be developed using a template provided by the department. So we'll be kind of making the decision on the language that's going to be translated on the sign versus what has universal symbols versus what you'd provide access to. So you could have a, just a website listed or a QR code that goes to a website that could have translations, because we recognize that there's a lot of text required on this sign, and translate, especially for situations where you might need multiple languages. The sign just could not be large enough to have all of the information in multiple languages. So we're going to try to use universal symbols as much as possible, but there may be some language, a small amount of text that would be in English and then translated, just to make sure that anyone who doesn't speak English would get the most important information, the key information without needing to go to the website to get the translation.
Susie, it's Josh. When you come up with your template, would you mind sharing it with a couple of us so we can mock out what a sign would look like? Because everything you said, I think, is of concern for us, the size of the sign, how much information we can jam in there. And if you're trying to translate, even if it's one word, to 5 different languages, the bigger the sign, the bigger the target it is for people to take or vandalize. So once you come up, before you finalize it, maybe float it around for a couple of communities that have diverse populations and see what we can do to make it work before you finalize it.
Sure,
Please.
I think we can do that. That's
Thank you.
reasonable.
Right, moving on with other questions that are in the chat. DCR owns the land where some of the public access signage needs to be installed. Are the communities responsible for getting approval from DCR, or is this something already agreed upon between MassDEP and DCR? So I've responded to this question in the chat, but what I do say is that MassDEP has reached out to DCR for an agency contact, as well as to the Fish and Wildlife. We expect to discuss with both agencies the issue of sign posting on state property. In conversations we've had with boards of health, people are concerned that municipalities don't have the authority to post on state property. So we're reaching out to those state agencies that own properties to discuss the posting of signage there. Catherine asks, how do you identify impacted municipalities and who is responsible to post signage in the impacted communities? And Phil Guerin also says, guidance states EJ populations affected by the discharge. What does affected by mean? And is it the EJ census tract where the outfall is located, or where those adjacent to the receiving water, or the entire city that has a CSO? I think if there's any part of the statute that puzzles me, it's probably this affected communities part. I don't know if team members have any thoughts they want to offer at this point, or should we try and take these particular questions offline? It seems like
I would
ahead,
just,
Susie.
for a brief answer now, and we will try to provide more, I'd say, we're really looking for the permittees to use whatever information is available to you to make your best judgment as to what communities downstream of you are impacted or across the river from you, depending on the situation. Whether it's anything that was identified in your long-term control plan, or if there's been modeling done for your particular discharges, and recognizing that this isn't going to be an exact science in most cases, because we know we just don't have enough sort of that type of modeling information available in a lot of cases. So just trying to make use of whatever information is available and make your best judgment, and then trying to answer a little bit more of Phil's question too. So I would say it's not just the census tract where the outfall is located. If downstream of you, the municipality that's directly downstream of you has one or more census tracts that's EJ, then I would consider that, yes, there is an EJ population that's affected by the discharge. Even if they're not right on the river, they may still use the river. So I wouldn't limit it to just where the discharge itself is located, but the areas that may be impacted by it.
Thank you, Susie.
Can folks hear me?
Yes, Kevin, we can hear you.
Oh, sorry. I've been trying to answer some of the other stuff. And
Now we can hear you.
my lips were apparently moving, but Susie gave a very good answer to this one here. This is a little difficult, obviously. I think that the people that drafted the legislation, weren't really understanding the technical difficulties in making these determinations. I think the best information we usually have is some manner of modeling that was done in a long-term control plan. But I think as far as the downstream impacts, it's not just what communities, it's really where are exposure points where they might have access to the impaired water. So, and I think we're going to get into the weeds of that. I think once you submit some plans and we sit down and start talking about what's reasonable in that regard.
All right, now I was on mute. Okay. Can we please define public access points? We've not defined that term in the regs. I guess I might want to take that question offline. I've certainly thought about it as, public boat ramps, public fishing piers. There are, I believe, some particular locations identified in the regs. Any other thoughts on that before we go to the next? Beaches, obviously.
Yeah, I think we can come up with some manner of definition in a Q&A document, Leldon. Obviously this isn't like an area where there's a hole cut in a fence, or something in which we see sometimes right at the CSO outfall sites we've seen it. So I mean, it has to be a legitimate public access point. And that's inactive or some manner of active use.
Thanks, Kevin. All right, this question, I'm going to read the question and then an answer that I put in the chat. So Although Chelsea doesn't have many swimmers, there is a large boating community with signs need to be placed at all boating docks. Public boat ramps and public fishing piers would require signs because they provide the opportunity for secondary contact recreation. And then the follow-up question is, would we need to post notifications at private boat docks as well? So my understanding is notifications are not required to be posted at private boat ramps that are not open to the public. But if there was a private ramp that provided access to the public, that could qualify as public access point. So I think that's a question or issue that perhaps we should address when we develop response to the question about how to define a public access point. Okay, Charlie Jewell asks, regarding meter deployment, can we clarify what DEP considers as a meter? Does it include sensors such as level sensors or inclinometers? Kevin or John, do one of you who might have more familiarity with some of those devices want to speak to that at the moment, or?
Yeah, I thought we might have actually modified the definition, but maybe we didn't in the final regulations. But to Charlie and everybody, I would say any type of device that you're deploying that's intended to confirm either that an activation has occurred or to quantify that activation would really qualify as some manner of metering device. And nowadays, the use of things like inclinometers have been very effective in confirming that a discharge has occurred, even when, a depth monitor by itself may not. So all of these devices, in my mind, would qualify as a quote meter.
Okay, and so Josh asks if we could define a 24/7, 365 facility. Plants and collection systems are staffed with different personnel. He mentioned earlier verbally that people are maybe staffing the wastewater treatment plant 24/7, but not the collection system itself. So I think that we were referring specifically to the treatment plant. I don't know if others have a thought about that.
Well, I think we're thinking about the treatment plant primarily, Leldon, but, this is a good question and a good point. And like many things in the CSO world, I don't think it's necessarily a one size fits all type thing. We have in this region permittees whose collection systems, they maintain and who have contract operations. And, actually that creates some complications, and it's created some adverse impacts itself sometimes. But I think that there needs to be good communication in those circumstances and good definition of responsibilities. So I think in your CSO plans, assigning the responsibility and how you're going to carry out the requirements is going to be really needed. But as to, really answering directly how that would translate in discovery, I think that would require some review and discussion.
Okay. This question is, there are places where people can access the water, but it's not a designated swimming area. There are locations where swimming is prohibited. Would these locations require signage? Again, my thinking had been that it would not, that they had to be designated public access points. Anybody else thoughts on that? Okay. For CSO facilities that are staffed 24/7 during events significant enough to generate CSO discharge, it is typically a heavy rain event, and the facility staff is already occupied in implementing high flow management plan activities. The thought that just because a facility is 24/7, the operators have time to divert and complete the new discovery requirements within 2 hours is not realistic. All facilities should have 4 hours. We're aware of, the difficulty and the activity of staff to manage high flow events. It was something that was of concern to us as we were drafting regs. And we do recognize that this is something that is, additional burden during a period when there's already a lot of stress at the plant and a lot of stress on the employees who are trying to manage that flow. However, this provision is being promulgated as we've discussed it, as John presented, and I don't think there's opportunity to change it at this point in time.
We do, I'll just add to
yeah,
that,
Kevin.
that, we do have some permittees that tend to, or that have at times issued notifications based on solely on the meter information that comes in. And because of some of the competing demands, they're not able to go through a rigorous discovery process, or in some cases, maybe any discovery process. So that is a possible outcome under these conditions. Obviously, not attending to discovery needs may mean that there's a more likely chance that there could be a false positive reported, and we've seen that. But with some of these parameters have been established in the law, and I think that we would encourage wherever possible that these discovery steps be taken. But if they're not taken, then the assumption prevails that it's a discharge.
Okay, if an overflow happens at 2 a.m., would we need to get the notification out at 4 a.m.? John or Kevin, do you want to, or Susie, do you want to speak about sort of the discovery of events and the timing of that?
Yeah, can you repeat that question?
Yeah, if an overflow event happens at 2 a.m., would we need to get the notification out at 4 a.m.?
So you would have your discovery window. So your meter or whatever triggers that. It's a 24/7 facility. So you have 2 hours to discover your event. So that would get you to 4 a.m. And then you'd have 2 hours to issue the public notification. So that would get you to 6 a.m. It doesn't necessarily buy you a lot more time, but the expectation would be yes, in that scenario, that the notification would go out at 6 a.m. Now, this is why we have extension ability in the regulations, approval by the commissioner. So in that scenario, maybe it isn't feasible. So that would be something that would go in the extension and explain what the limitations are and when the expected notification would go out. So that's part of the plan and part of the extension request through the commissioner.
Thank you, John. Okay. Just looking here. There are a few questions having to do with this 8-hour issue. Can the cessation notification update be issued less than 8 hours after the initial notification if the event stopped earlier? So my understanding is yes, it could be issued, but it creates a situation where if it commences again within that 8-hour period, the rainstorm continues or sort of recurs that's causing the overflow, then it would necessitate an additional, additional notification. So you have 8 hours, you might want to take the 8 hours unless you're confident that the event causing the overflow or discharges, has ceased. What does DEP consider a cessation of an event? Is there a time period when a CSO ceases and reactivates that is still considered the same event? And I believe others, if you want to speak to that, but I think we've considered anything within that first 8-hour period to be the single event, right?
Yeah, that's really the way.
Sorry, go ahead, Kevin.
Well, yeah, that's why the 8 hours is really an important threshold. Frankly, we don't see a ton of CSOs that in this region that persist that long or longer, but there are occasions. But what we're trying to address here by establishing the 8-hour for reporting a cessation or an ongoing event is to address some of the conversation we heard about that there are overflows, as Leldon said, which stop and start, stop and start over the course of what pretty much is the same rain event, although it's, the intensity may vary a little bit. So I think it would behoove the permittees probably to make a single cessation notice at 8 hours, which would encompass, the full time and volume of, or at least an estimate of that has occurred in that time frame. And so if the issue of cessation notice at that 8 hour point, then anything beyond that would be considered a new discharge. I think that was kind of the more direct question.
There's a question I hadn't considered until I saw it here in the chat, which is what if communities do not have IT staff working 24/7 to post their notifications on the website? I don't have a great response. I don't have a response to that one at the moment. I don't know if anyone else has thoughts about that.
Yeah, that's our current problem too, right? Well,
Yeah, we're
in the same box, by the way.
Spent some time on this issue, yesterday with our IT.
But that's a limitation you'd put in your plan. If IT isn't able to address it in that, window, then that would be an extension that you'd want to request in your plan. So you note that overnight events, may require an additional extension on when it gets posted to the website. There's understanding that, there's different scenarios that are going to unfold on this that are going to have different timelines on when they happen, how they happen. So that's why we want to have these plans in place so we can have, make sure that all these different scenarios are being addressed. So I would say that's a good situation that you would want to explain in detail in your preliminary notification plan on posting to the website.
Thank you. Next question from Betsy Riley is detection and reporting must be done within 2 hours and then update every 8 hours. But also we need to continue monitoring to capture the end of a discharge within 2 hours, ? So monitoring needs to be ongoing for a discharge that is greater than 2 and less than 6 hours in duration. Basically requires a lot of ongoing continuous monitoring and tracking of the time that has elapsed.
So Leldon, my point on that one, and I heard what Kevin just said, but so I guess if you have a discharge that's, let's say it's 3 hours long, so you've done your 2 hour, now you're kind of watching the clock, waiting for the 8 hour, but it stopped at 3, so you've got to get an update done in 2 hours. Is that a requirement since it ended, or can I wait because maybe the storm is still in the area?
If it's if it stops before 8 hours, you don't have to notify anything until 8 hours. So if it's only 3 hours long, you don't have to notify within 2 hours of the 3 hours. You don't have to notify until the 8 hours. So the every additional, so if at 8 hours, you say it's still ongoing, then when it does actually stop, you'd have to notify within 2 hours of it stopping. But we're thinking there's not that many that are going to exceed that 8 hour time frame. So it's going to be a rare situation.
Got it. Thank you.
Good. Thank you, Susie. Can we confirm if January 12th, 2023, the date of the final CSO public notification plan is due, is also the deadline to have all of the signs installed?
It's not.
Go ahead, Susie, you want to take that one?
Yeah, so there's no specific date, there's no specific deadline when all the signs have to be installed. In the regulations, it says that it's by a date that's specified and approved in the CSO notification plan. So when you're doing your plans, you should be proposing to us, these are where the signs are going to go, and this is the date we propose to install it. And then if we approve that, then those are the dates, and there's no like drop dead that they all, has to be by July 12th, 2023. So that being said, if you propose dates 5 years in the future, we're probably not going to approve those, but there will be some recognition of if one community has a lot of signs they need to install, then there's probably going to be better justification for stretching it out versus one that might just have, a couple that they need to install. So we're trying to give some flexibility there in terms of how much each community may have to do.
And Susie, just one more refinement of that response. So the request that permittees are to make to identify a date by which their signs would be installed, does that request come in the preliminary plan or in the final plan?
Preliminary plan.
Okay, thank you. Next question is the permittee responsible for signage outside of their service area? For example, is Lowell responsible for signage in Tewksbury, Dracut, etc.? My understanding is that they are responsible for sign postings within their own municipal boundaries. Is that the same
No,
understanding
it's
you have?
any areas that are affected.
Okay.
Public access points affected by their discharge. So if that is outside of their municipality, yes, they're still responsible.
So if a model predicts that there's, an affected area down gradient in another municipality, then the permittee should be reaching out to the Board of Health in that other community?
Correct.
Yeah. Okay. If we get these DEP, DPH, and other required contacts to sign up on the subscriber-based system, will that satisfy this requirement? Betsy, I didn't quite understand which requirement you were referring to in this question.
Yep, so there's a bunch of required notifications to DEP folks. I think you were going to give us some emails to use for this purpose. I think there's Board of Health officials and I can't remember who else was on there, but those were in addition to having the subscriber-based system where the public can sign up. If we got DEP, boards of health, and others that you have on this required list of notifications, these agencies, would that count?
I think as long as they're getting the email or the text, it doesn't, I wouldn't say it matters whether they subscribed or you manually added them. As long as they're receiving it, I think that's what matters. Does that answer?
That it answers it for me.
Yeah, good. All right. You have to have signs in place by July 2022 before a plan is even submitted and approved. So Susie just spoke to this. So the date for specifying sign placement would be something you would propose in the preliminary plan. How does a permittee determine whether a news organization specifically serves an environmental justice population?
We want to do a little more research on that, and we can put that in the QA document.
I think that's a good idea. Okay, Mickey, hi. So you have a question. An event ceases anytime the overflow has stopped for 2 hours in 1604 parentheses 8. It says you must issue a public advisory notification that the overflow has stopped within 2 hours after an overflow ceases.
So that's only if it's gone more than 8 hours. If the discharge has lasted more than 8 hours, then you have to notify within 2 hours when it ceases. Otherwise, if it's less than 8 hours, you only do that notification at 8 hours, and that notification either says it's stopped or it's still ongoing.
Okay, so if the overflow stops at hour 3, you've already made your initial notification. You don't have to make another notification for 5 more hours.
That's right.
Okay. Very good. That clears it
Yeah,
up.
we're trying, that was a change from the draft to final to, because try to address that discharges do start and stop, and we don't want people to have to, they say it stopped, well, then it starts again an hour later. Now they have to do a new notification for a new discharge, and it could end up being a lot of discharges or a lot of notifications for what's really just the same event. So that was the reasoning behind that.
John Sullivan asks, at public access points, do signs have to face both landward and seaward?
We didn't specify in the regs, so I would say no.
If an access point is impacted by CSOs from several permittees, who is responsible for the signage? Is a single sign acceptable versus each permittee having their own sign. Also, how are the public health warnings issued if one community's Board of Health deems an event requiring a health warning and the other doesn't? I would indicate that there's, one sign is sufficient. Perhaps you can collaborate to provide the single sign if there's an access point that is affected by more than one CSO. How are the public health warnings issued if one community's Board of Health deems an event requiring a health warning and the other doesn't? So there are criteria that specify when a Board of Health is to issue a public health warning. And so I don't think that there should be difference of view about that. I know we talked about this issue at some point in resolution of the final regs. Susie, do you?
Yeah, I would just say there's the one provision where, so we specify a public health warning is required when the, a discharge is past a certain, in longer than a certain duration, depending, well, all SSOs, and then for CSOs, it's if it's 2 hours or partially treated 2 hours or greater. But then there is the Board of Health can decide to still issue a public health warning if it doesn't, even if it doesn't exceed that threshold, if they think there's a risk to public health. So if there's a CSO discharge that only lasts an hour, the Board of Health isn't required to issue public health warning, but they can decide on their own that they still want to and issue that. So it's really up to the Board of Health in that community. So if two different boards of health in adjacent communities decide to do something different, they can. They don't have a lot of discretion though. We have spelled it out for them mostly, and it was really if a Board of Health decides to go like above and beyond and issue one when it's not required, then that's when there may be a difference.
Thank you. We don't have any treatment plants. We get email notifications when there's an alarm that indicates a possible discharge. Would we need to send out notifications in 2 hours or 4 hours?
For a CSO event, you would get 4 hours, as John kind of mentioned earlier. It would be 2 hours for, you would get the alarm notice. You would have 2 hours to basically, if you had the resources to check if it was an actual or a false positive, that would be allowed under the discovery realm. And then you'd have 2 additional hours to make the notification. So you'd have a total of 4.
I thought it depends on staffing, 24 hours, 24/7.
For CSOs, John, was based on metering notice, though, right?
There's still a difference in the discovery time based on staffing for
There is.
CSO.
Okay.
Yeah.
All right.
So it would be 4 out, 2 + 4 if you don't have 24/7.
Okay, yes.
Right.
Thanks for the correction.
Swimming is not allowed on the Charles River, so signage would not be required. So the entire coast of the Charles River would be considered accessible and subject to signage.
One response is it wouldn't just be swimming that's the issue. It could be boating too. But there's, gonna have to be in areas like the Charles, some sort of discretion to figure out where the signs go, because in some areas, yeah, it's a very long length of river that you could just get in at any point. And obviously you can't just put signs everywhere up and down the river. So I think, work with the Board of Health to come up with a reasonable proposal about where signs should go.
Okay, next question. Chicopee's new NPDES permit requires CSO signage in English and in Spanish or include a universal wet weather sewage discharge symbol. If they include the symbol, are they relieved from having to place signage in more than English?
The language, so for the signage that's at the outfall, you could just go along with what's in your NIPD's permit, but for the public access, signage at public access points, I believe the language in the regulation says, provide access to translations and use universal symbols. Yes, shall provide access to translations in the languages most appropriate and shall utilize universal symbols. And you know, the reason for using the symbols and the translation, so there's a good amount of text that's required on these signs, and the reason that there is a lot of text required on these signs is because the statute required it. So we were obligated to put it in the regulations. So, you know, we recognize that not all of that text can be translated on the sign. So that's what, but we do think that folks should be able to view a translation of that text in some way. And so we're not requiring it's translated on the sign itself, but that there's access to a translation of that text that could be on a website. But the universal symbols are also required because we want folks to be able to get the most important message, even if they can't read English, you know, knowing that there could be hazards associated with using the water body. So, so I guess putting the universal symbol would not relieve you of the needing to provide access to the translation, because it does say and translation and universal symbols.
Thank you.
Is a permittee responsible if the independent Board of Health fails any notification responsibilities required of them? The answer to that is no, that the statute does grant to DEP authority to take action for a Board of Health if they failed to, you know, carry out any of those responsibilities. The regs also included this. This was a point within public comment that we got some negative reaction from boards of health. You know, we tend to prefer to work collaboratively with boards of health, as we do prefer to work collaboratively with permittees, but the regs do specify when DEP can, you know, take what constitutes violations and when we can, you know, when we can take action. Paul asks, can you talk more about the responsibilities of boards of health, particularly downstream ones, and the required signage? I will mention that we intend to reach out to boards of health. I'm scheduled to talk with at one of the health boards conferences in the coming weeks. Do we want to try and cover what the responsibilities of the boards of health are here?
I didn't see the exact question in the chat. Could you repeat what it?
Sure. Can you talk more about the responsibilities of boards of health, particularly downstream ones, and the required signage?
Sure, we can cover that. So if the Board of Health is notified by a permittee of a discharge, that discharge meets the thresholds in the regulations, which are, you know, a duration exceeding 2 hours for partially treated or CSO or any SSO, then they're required to do issue the public health warning, which is using like their existing emergency notification system. And then they're also required to either post a temporary sign at access points or utilize a permanent sign that's already there that has some way to be modified to provide information that a discharge is currently happening, whether it has some kind of flashing light or electronic message board, or just somewhere that they would come and post a temporary sign sort of on in a kind of blank place on the permanent sign. So we're kind of open to how that's done, trying to leave some flexibility that potentially allows boards of health to not have to go physically out there and post a sign, but they do have the option to do it that way if they want to. I think that covers it.
Okay.
Yeah,
Paul,
we can hold that one till next week too. Maybe that might be better to address more thoroughly on Thursday's meeting next week.
Okay. So Phil asks, CSO notification plans are subject to public comment. Is that the preliminary plan too, or just the final plan?
That's just the final plan.
Right. Yep. While you were telling us today about being reasonable in plan approval, will that be the case once you get public comments from those who demand more? I certainly hope so. We certainly intend to be reasonable when we receive public comments. I think, one of the things that has benefited me particularly, and all of us greatly, has been the expertise of the folks who worked on these regs. And I think that we'll use their expertise and also that of the regional program staff in sort of evaluating what's reasonable and certainly try to be reasonable in exercising our authority. How do you establish the extent of downstream impacts? This could depend on flow in the river at time of discharge, volume of discharge, and degree of attenuation. Will DEP provide guidance on length of reach downstream from discharge point affected as a function of discharge volume? Kevin spoke to this a bit earlier. We think that some of the best information available is from models that may exist at some of these discharges. As I indicated earlier, this is a part of the statute that is, hard to put an exact, hard to predict exactly what the extent of an affected area is, because it depends on so many different factors. So we'd prefer that you try and make those predictions using modeled or other information that you might have on hand. Any other thoughts or comments about that, you guys? Okay, what is the public health issue in tertiary treatment, like a polishing filter is bypassed? I don't think that there's a public health issue, but that was a decision that was made in finalizing the regs, is that it could be considered partially treated. And so the reg does include, partially treated would include if you're bypassing the tertiary treatment. I think in many instances that you might also be bypassing the secondary treatment as well, which would have more public health implications. What qualifies as a news organization? Public news, private paper, municipal Twitter, Facebook account, etc. So we've not, I don't think we've considered social media, but we are leaving to the permittees, to identify the news organizations. And so we've not tried to define that ourselves in the regulations. We're going to look to you guys who have more familiarity with the types of media services that are in your community. Would we say that the Boston Globe or the Boston Herald serve environmental justice populations? They serve the Metro Boston area. I think we have indicated earlier today that we're going to reach out and see if we can get some more guidance from our EJ director on that particular issue. Okay, incredibly, we've gotten to the end of the questions in the chat.
We might have skipped over one.
Oh, did we? I'm sorry.
Did we do are the Board of Health signs different than the permittee signs?
Oh, I'm sorry, I missed that. Susie, do you mind taking that one?
Sure. So I think the answer is sometimes yes, sometimes no. So the permittees already have the requirement for the signage at public access points. And there's going to need to be coordination between the permittees and the boards of health to determine where those signs are going to be installed. And also whether is the Board of Health going to want to use those signs for their signage that has to be done at the time of events. There's going to have to be some coordination on how that will be done, and whether the Board of Health wants to just go put up a temporary sign at the same location, and in that case then it would be a different sign, or whether the permittee and the Board of Health decide that there's going to be some kind of sign that can be modified remotely because it's like an electronic message board, which, we understand things like that are obviously more expensive than a permanent sign, but, maybe folks want to go that direction. Or sorry, more expensive than a temporary sign. So it's gonna kind of have to be worked out between the different permittees and the different boards of health, whether these end up being two different signs or the same sign.
Thanks, Susan.
Can I ask a follow-up to that, please, Susie?
Yes.
So would that have to be agreed upon and included in the preliminary plan? So the agreement between Board of Health and the permittee signs and what we are deciding to do, or do we have some time to hash that out by the final?
So at a minimum, you would need to know the proposed locations for the signs for the preliminary, whether or not it's going to serve the purpose for the Board of Health. I don't think we said it had to be included in the preliminary plan, but the Board of Health is going to need an ability to be having the signage as of July 6th. So, if the permittee has in place the signs at that point, or the signs aren't going to be used for that purpose, then I guess in the interim, the Board of Health would have to be just doing their own temporary sign. But in terms of, I'd say, if you have worked that out at the time of the preliminary plan, I would put it in there. But otherwise, I think you're only required to say what the locations are in this preliminary plan. I don't know if anyone else wants to add to that, or we can think about that a little bit more before next week. And I saw Quinn's question about, do you need to place signage in Connecticut? No, you do not.
I got a quick question.
Yeah, go ahead.
If the loading dock of the public transit, public ferry down at Rose Wharf says, no, you can't have any signs on my property. You will put a sign out on Atlantic Ave and people hope they figure it out. How do we deal with the private property issue where it's clearly public, but they don't want a ugly sign?
I think, John's referring, I think John is referring to, under Mass General Laws, Chapter 91, it gives the Commonwealth and the public rights of access on all filled and flowed tidelands. And so, the public acts, what constitutes or what is available for public access in cities like Boston and much of the shoreline area is greater than what you might think of in more inland communities. It's an interesting question. I hadn't thought of it quite from that perspective. I think I'd like to take a little bit more time, maybe consult with our Chapter 91 folks. I don't know if any of the other team members have thoughts about it at the current time.
I appreciate it. There's a lot of spots along Boston Harbor. Besides us all wearing sandwich boards, walking around. We're looking for some kind of permanent idea.
Right. Okay, let us take that one back, okay? And Don Goodrose says, what about a permanent sign with a movable panel that DOH personnel can flip as needed? Something along the lines of what trucks use to show classification of hazardous materials being hauled. I think that could probably qualify as a temporary sign. Yeah, I see Susie nodding, so that's one that I hadn't thought of. Might be a low tech and useful type of modification.
I have a question about when you notify a news organization. Does it matter or not that they publish the information?
Doesn't matter. The only obligation for the permittee is to notify them if the newspaper doesn't do anything with it, then it's okay.
Okay.
Okay. And Betsy had a question about translations that she'd like to ask.
Yeah, and actually, I wanted to get back to just a quick question on the signs, because John was mentioning, along Boston Harbor and the walkway, and is there like every so many feet? I'm not sure if this got asked or answered anywhere, but like, how frequent does a sign need to appear if you have kind of this long walkway along, the Charles River or, anywhere else?
Right. Yeah. We've not specified it. There's no distance specified in the reg. We've alluded to the fact that we want to give permittees, discretion about what they propose in their plans. And I think that this is an area where, we're certainly interested in hearing what a permittee would propose. We don't have, at the moment, I don't think we have further guidance about that.
Okay. Now, as far as the translations, this is something I've not had to deal with, but as I'm kind of thinking about it, it sounds like we can't just have a translated. This is important information. Please ask somebody to translate. It sounds like we're actually going to have to translate the messages. So if we have a 2-hour notification, CSO is discharging at such and such a place and time, how are we going to get all of these translations out there? I mean, that sounds like a real issue.
So I would say you'd kind of need to come up with some templates in advance and get those translated. And the things, for the most part, I'm thinking the things that are going to change event to event are like, the date, time, things that wouldn't necessarily need to be translated because they can just be in a numeric format. The water bodies may change, right, from one to another, but having those in English is probably fine, or might be the only possible option anyway. So I think you might need to think, like, for the public advisory notifications, obviously, like the different permutations of what it might be, get that translated in advance and have them sort of ready to go for when the events actually happen.
Oh boy. But then it's also like we're sending out it could be 5 different messages, English and then whatever other languages. I definitely appreciate your point, and I think you're right, Susie, that a lot of it can be kind of boilerplated, but there's still also kind of that, how do you get it out? Plus, if there's any kind of web page information that's a little more, kind of static, but as we know, web pages are updated all the time, and so there's going to be a maintenance element to that. There's a lot to it.
I'm just double checking the regs. I don't think you actually have to send out multiple messages in different languages, because I think we did, public advisory notifications shall be translated into or provide access to translation in other languages. So if you send out an email notification when there's an event, that could be fully in English, but have a link to your website. And then on your website, you have it in translated into multiple languages. I know that still doesn't fix all of your challenges, but it does avoid the situation where you have to send out either an email that in the text of it has it translated into 5 languages, or 5 separate emails in the separate languages. You could just send out one, and then you have the translations on your website. I know that still you still have the challenges of getting everything translated and getting that up on your website. But it does at least avoid multiple messages or a very, very long message, which in the case of a text message might not even be possible if there's limitations on the size.
Yeah, there are. Yeah. Okay. Well, there's definitely a lot to this. A lot will have to be thinking, just on that one particular element. There's a lot there. A lot to unwrap.
Right. And Luchika points out that there are languages that do not use the same numbers. Lachika, do you mind just sharing what you know about what some of those languages are? Because I think one
I
place.
know in Somerville is Nepalese,
Uh-huh.
and even Arabic.
Yep.
These are the two that just came to mind right away, but I am sure there are others.
I'm wondering
Probably
about Khmer
Yeah,
as well.
any, I guess any language that uses different characters, like Chinese or something like that.
Yeah.
Might not.
So coming up with a template is a great idea, but then, you know, the numbers might be complicated. Same as translating in real time, because we don't have translators working 24/7.
All right, let us take that under advisement. Let's see. Quinn, you have a question about the Board of Health Public Health Advisories. You want to ask that?
Yeah, sorry if I'm not having this right. So when the Board of Health has to put out their advisory, there was a stipulation that if the community has a reverse 911 system, that it must be used, I believe. So we do. Is the message having to say that there's a public health advisory at 18, like if all my CSOs overflow in a storm, which they're going to, do I have to have them list every location in that message? Or do I have to make 18?
John, can you
phone
scroll
calls
down a little
or
bit? I think it says, so that number 3, when more than one discharge or overflow can occur on a water body, they can determine whether the first public health warning is sufficient. So if there's if one of your CSOs discharges to the Connecticut River, and 2 hours later another one discharges, the public health or the Board of Health has discretion to decide, okay, I think it's good enough we did it for that first one because the second one is also in the Connecticut River, and it's there's not really any new information. Or if for some reason the Board of Health does think they need a second one, they can. They have the flexibility to do that. But we were with the that provision there, number 3, is to try to prevent having to do a separate public health warning every single time that there is a CSO discharge. If it's all like the same storm and the same water body, you probably cover communicating the risk with one. Yeah, you could just, because I think it only says that it has to, it doesn't, you don't have to like list the specific outfalls, but just the bodies that are impacted.
Okay, excellent. Thank you.
Okay, we've got one more question, and that's about all we have time for. I know Kevin and I have another meeting coming up in just 4 minutes. So is the Board of Health, oh wait, we got another one in the post after I said that. Do signs need to be on a post, or can they be on a building embedded into the ground, or something movable like a trash receptacle? We've not specified how they have to be posted. I guess I might, you want to be cautious about something movable or something that is removable, because the goal, of course, is to notify the public. So if it's able to just blow away or be moved off by someone else, it's not ideal. But we've not gone into detail about what are the requirements for how that posting occurs. And then finally, is the Board of Health and a permittee's community responsible to update public health notices outside of their community?
Yeah, the Board of Health, each Board of Health doesn't have any responsibilities outside of their own municipality.
Okay. So tell me, what do folks think about the need for another meeting? We have it scheduled for next week. Are there topics we might want to cover? Do we want to try and get some of the answers to some of these questions that we couldn't answer today and discuss them? Should we leave that on the books? Would people like to take some time to look at the template and then maybe provide us with written comments or be able to discuss comments specifically about the template? Because I know that you didn't have a lot of time to, to actually read and consider the way the template is presented. And that was one of the things that we were seeking to do.
I'll jump in and say yes, because we didn't have much time to look at the template. It would be good to have some time to get together questions on that.
Yeah, I agree with Wendy. I think if we next week hold that meeting, we can answer some of the questions today, cover a little bit more of the Board of Health requirements and cover the template in more depth. Allow everyone to ask their questions and kind of maybe revise that and tighten it up a little. So I think that's a logical plan.
Yeah, good. And I'm seeing other comments in the chat that indicate people also think it would be useful to have more time. So let's keep that on the books. I do need to wrap up for this next meeting. I want to express my appreciation to everybody that attended. I also want to express my regrets to the fact that there was a glitch in the promulgation process. It's a very complicated process, and unfortunately, it went awry. And believe me, no one has regrets about that more than I do right now. So, we've provided you with a provisional copy of the regs, and that should be useful to you as you consider, your questions that you asked today, others that will come to mind in the template that we've provided. So, we'll look forward to having that conversation and look forward to talking with you again next week.
Thanks.
Thank you.
Thank you. Thank you, Leila.
Yeah, you're welcome. Bye.